Hi there, you're with BQ Prime, and this is the fine print. The merger will go through whether I'm CEO or not. Z Entertainment's Punit Goenka said this in an interview to two business dailies today. Now, is the Z-Sony merger, sans Goenka, the only option now? How will Sony navigate the various legal tangles that the merger has landed itself in? Will the deal commercials change? Will shareholder, creditor, and regulatory approvals need to be taken all over again? Well, to answer some of these questions and more, I'm joined by S&R Associates Rajat Sethi. Rajat, welcome to the fine print. Rajat, before I come to you, I'd want to recap for my audience some of the legal tangles that the merger is facing. The first is, of course, SEBI's interim order against SL Group entity, Shirpur Gold Refinery, where some of the Subhash Chandra family members are the indirect promoters. The second is, and of course, this was via an interim order on April 25th. Then, of course, there is the bar by SEBI on Punit Goenka and Subhash Chandra from acting as KMP director in any listed company. The third legal tangle that the merger is facing is by various lenders who have not directly lent to Z, but they have lent to several SL Group entities where Chandra has guaranteed the loans. And the three lenders are Axis Finance, JC Flowers, and IDBI Bank. The first two are currently arguing before the National Company Tribunal, and IDBI Bank rather chose to take the insolvency route. The bank's petition got dismissed by NCLT, but it may still choose to appeal it at the appellate tribunal. Mr. Sethi, I will come to the various scenarios that are now possible in this deal going forward. But at a broad level, do any of these three legal sort of threats likely to kill the deal?
I don't think. I think if for the deal to go through by Sweeney, I think there is still ways to do it. The biggest issue seems to be in relation to whether Mr. Goenka continues as the managing director of the new merged entity. The SEBI order suggests that is not possible at this point of time. So that seems to be the biggest impediment. The scheme records that he will be the managing director of the merged entity for a period of 5 years from the date on which the scheme becomes effective. So even if that SEBI order is accepted and it's subject to challenge right now, it's going to come up before the SAT. I expect there'll be further appeals as well. But even if that order were to be accepted, then at the minimum, the scheme will require changes. And you referred to various press releases. The parties are already indicating that they are considering alternatives for the merger to go ahead. So I would say that at this point of time, there are certainly impediments, but it would be premature to say that the merger is dead. I think there are still possibilities for the merger to be restructured, perhaps, even if the appeals which have been filed against the SEBI order, even if those are dismissed.
Okay, so let's talk about these possibilities in slightly, better detail. The first scenario, of course, is that the deal goes through, and the provision or the clause in the scheme of arrangement where he's supposed to be the MD and CEO for the next 5 years from the day the scheme becomes effective, that is sort of taken out of the scheme of arrangement. In which case, how is it likely to pay out? Will the deal commercials change to your mind? Will the deal require shareholder, creditor, and regulatory approval all over again? Because as we know, the NCLT is also looking at whether, in light of these interim orders, the exchange approval that has been given to the deal, does that need to now get reconsidered? So with the change in this major provision, do you believe that that process will require approvals all over again?
Yes, I think to my mind, it will set the clock back by Aswini, because the clause which you refer to, which says that Mr. Goenka will be the managing director, in fact, that clause is framed as being an integral part of the scheme. So that's the way it's written, and that's the way it has been approved by the shareholders. So it's quite likely that if the if a new deal structure is considered and that those provisions are no longer uh, applicable, then that the scheme has to be taken back to the shareholders. So, and also if there's an amendment to the scheme, a material amendment to the scheme, then potentially the SEBI and the stock exchanges get involved again. So all of those would be issues to consider. Timing obviously will be important if the merger has to go through, because if one loses time on this transaction, then the greater the risk of either other parties coming in or objectors seeking to press further on their objections.
Sure. What do you make of the fact that Sony seems to be committed to this deal at this point? That's what some of their statements seem to indicate. Um, how likely is it in a scenario like this, Rajat, that the promoter who may have been deeply involved in this case, Mr. Goenka, Mr. Chandra, in a deal of this nature, with that clause being dropped off, would still be willing to, carry through the deal as is, though their shareholding is at what, 4% now. And also, when I said commercials, I also meant that the non-compete that Sony is giving the promoters, will that be affected in any fashion as a result of, let's say, that clause getting dropped off?
Yeah, I think you're right, Payaswani, that this clause seems to be a fundamental part of the commercial arrangement that was struck between the parties, which is reflected in the merger scheme also. So if that undergoes changes, then I expect there will be a broader discussion between the key parties. And I think that discussion may already be taking place because everyone will be preparing for plan B type of scenarios, assuming that the appeals against the SEBI order are not successful. Then, in order to present an alternative scheme which complies with the SEBI order, then those changes will obviously have a broader effect on whatever the commercial arrangements between the parties originally were.
Okay. Let's come to the second scenario, Rajat, where let's say the clause stays and the promoters don't budge. Sony agrees to play along. In that case, would the Securities Appellate Tribunal and then probably at the Supreme Court level, whichever party sort of loses at SAG, those proceedings have to reach some sort of fruition before this merger can move forward?
Correct. That would be the expectation. And I would think that given that this clause was an important part of the deal, I would expect that the Z promoters would take it to its logical conclusion before they give up on this clause. So I would expect that indeed they would litigate it, and they do seem to feel strongly about it, so that they would litigate in respect of it. The other sort of sub scenarios which could play out is they have said that they were not heard by SEBI. So before this order was passed. So then it goes back to SEBI again. They are heard before SEBI. SEBI passes the order again. Seems to be like some long drawn out type of scenario, which consumes a lot of time. The risk, I think, with losing time, obviously, is that you sort of open the doors for third parties also to present alternative deals. I mean, risk to the merger. So I think that everyone will also be alive to. And that could perhaps be one factor which weighs in making a determination on how far do you prosecute or appeal against this order, or whether it's just best to modify this clause and present an alternative deal.
And I mean, is it safe to assume that Sony would want to close this deal as soon as possible? When I said safe to assume, in the equation currently, does it look like Sony has the upper hand and it might be able to prevail in saying that let's drop this clause, let's close this merger, let's not give any other competitor in the market to come and make a hostile bid?
Yeah, I don't know whether Payaswini they have the upper hand or not. That I'm not sort of privy to the discussions. But certainly one can say that they remain very interested in the deal. I think that is a safe conclusion based on whatever we have heard and seen. So they remain interested in the deal. They are continuing to try and expedite matters. They've issued a statement, a public statement to that effect. And the target is a priced asset. So I expect they will do whatever is within their control to complete the transaction. So from that perspective, they in terms of commitment to the deal, I don't think that seems to have wavered at all.
Right. Like you said, Mr. Sethi, we're not privy to the specifics of it, and we don't know for sure what Sony knew, didn't know, or how much was disclosed to it in terms of the investigations that SEBI was carrying out. But I'm just at a slightly broad level trying to understand that if Sony knew, would it have factored it in the fund infusion that it's doing in the merged entity? Those kind of realities, do you think get accounted for? And maybe Sony was somewhat prepared for what the facts that are now playing out.
So obviously the SEBI order by Sweeney has just come. I think there were at the time, and also the other relevant factor is that the merger agreement was signed more than a year ago. So one has to look at it in hindsight and see what they were aware of and not aware of. At the best of times, it's a difficult question. But I expect that as a sophisticated party, they would have gone into it with the appropriate level of diligence until then. I don't think one can assume that they've been blindsided by anything. I think many of the things, to the extent that they were available in the public domain at that time, in terms of whether the risk could become more acute to the merger, probably they would have weighed in some of those circumstances. The merger process itself is a very public process, and they would have expected some opposition to it. This deal has otherwise been in discussion for a long time. There have been other interested bidders as well. So I think they would have expected a fairly intense type of process. Whether they could have expected that this particular order from SEBI will come saying that Mr. Goenka cannot hold any director positions, perhaps not. That, 18 months ago, if you had asked any commentator, they may not have been able to come up with that possible outcome. But, obviously, in terms of different scenarios, etc., and in terms of planning for those, I expect they would have taken a lot of those into account.
And that would reflect in what Sony is bringing to the table by way of money.
That would be one of the things, I think. I think that would certainly be one sort of relevant factor. But I think the key thing with all of these merger processes, it's such a public process that any merging party has to be prepared to deal with new situations which emerge from time to time and deal with them fairly quickly in order to move ahead with the process or abort it. And I expect that they would have, given a lot of thought to how they want to deal with the situation which is currently playing out.
Right. How do you think that, or how do you probably see the lender situations, the ones that are opposing, the merger at NCLT play out? Because they're not direct lenders to Z, but seems that they have given loans to group entities. which have been guaranteed by some of the promoter entities. Um, how do you think that unless Zee goes ahead and settles with them, of which there is no indication right now, or rather those entities go ahead and pay those loans, do you see them as a significant threat at all?
So that I think becomes more of a commercial point. Obviously, the merging parties will push back on those objections to the extent possible. And if they believe that the merger court is going to find some substance in those objections, then they may be forced to deal with, have an out of court settlement or reach some kind of a settlement with the lenders who have objected. That typically plays out in many merger processes, S&R. There will be some lenders, even though the requisite majority of shareholders and creditors have approved the merger. Technically, the merger court at that point of time, then if someone is still objecting to the merger, then they have to substantiate their case on why the merger process itself should be stalled. And I expect the merging parties will push back strongly on it. If for any reason the NCLT finds substance in those objections, then the merging parties will have to figure out some alternative solution. But I don't see that as a threat to the merger itself. Those would be, to some extent at least, they would be matters which would routinely come up in a merger, where lenders feel that maybe opportunity is too strong a word, but feel that there is some possibility of them recovering the amounts which are due to them in a more accelerated manner.
Okay. My final question to you, Rajat, that look, if Sony, Zee, Mr. Goenka, they decide that we want to, take the SEBI process to through the appellate stage, then the answer is fairly obvious that the NCLT merger process cannot run in parallel, because that process will need to, the SEBI process will need to come to an end before the merger proceedings can, move forward. If let's say that we go with this scenario 2, where we are saying that the clause which says that Mr. Goenka will be the MD and CEO of the merged entity, that has to be taken out. Process-wise, will Zee have to come to NCLT and say, hey, look, we now want to amend the terms of the scheme. Please allow us to do this. We will file a fresh scheme. And then the process that we talked about in terms of approval kicks off.
Yes, that would be the normal sort of way in which it should play out by S&R. It could possibly, Zee could well argue that, or the merging parties could argue that the process does not need to be repeated. But given the way that clause is written and given the way the merger has been presented, it does seem to me like it will be a substantial hurdle for them to cross, to be able to argue that they do not need to repeat the process and it should suffice to just drop that clause and proceed with the arguments on the merger scheme. So that I do feel is a substantial threat, that the clock is pushed back in relation to the merger process and fresh approval needs to be sought.
All right, Rajat, many thanks for joining us with your thoughts. And from what we've discussed so far, it's inevitable that the deal timelines will see a delay in either of the scenarios that we have talked about. And of course, we'll wait for June 26th. That's when the Securities Appellate Tribunal is set to hear Mr. Goenka and Mr. Chandra's appeal against the SEBI interim order. The merger matter is also listed before the National Company Law Tribunal on June 26th. But the hope and belief is that that process will not move forward until there is some sort of a resolution at SAT. Mr. Sethi, many thanks for joining us here on the Fine Print, and thank you so much for watching. Stay tuned to BQ Prime as we'll stay on top of this story. Thank you.